In studio now is Mervyn King, also known as the governance guru. He's been senior counsel, he's a former Supreme Court judge and a leading business person and chair of the International Integrated Reporting Council. Welcome to the studio, Mervyn.
Thank you, David.
You've been given a nice ball to kick straight away if you think of the Eskom story. We had the spokesman in here now. I thought he did pretty well in explaining, as far as a spokesman can, what was going on. But Eskom surely is a story of how governance should not be done, where you've got ministers, deputy presidents, the president may be behind it, the board, the chief executive, the chairman. Who's the boss? I mean, that's ultimately a question that governance shouldn't have to ask, but here it's certainly being asked.
Well, I think it's a good example of a basic tenet of good corporate governance, that one shouldn't have a split of authority and responsibility. The good governance dictates that shareholders should appoint the board, and the board should be appointed on the basis of the skills needed to make the best business judgment calls for that kind of business. Secondly, the directors then should appoint their leader, the chairman. And the boards, one of the board's main jobs is to appoint the chief executive to lead the management team to implement the decisions of the board. As soon as one gets a shareholder appointing the chairman and the chief executive, you've got a split of authority and responsibility. When something goes wrong, and it always does, the people who have liability and responsibility are the directors, and yet they haven't even appointed the person who's leading the management team to carry out the decisions of the board.
So it's the old problem of accountability without the power.
Yes, split of authority and responsibility.
So Mervyn, looking at Eskom, should we have a board in place? Why not have Eskom, the chief executive, report directly to the minister?
Well, the minister, first of all, the government is not the owner of Eskom. The minister is a representative shareholder of you and me, of all the taxpayers of South Africa. The taxpayers of South Africa are the providers of capital to Eskom and the lenders of money and the guarantors of loans to the company. So the minister has a duty of care to all the taxpayers of South Africa to make sure she selects a board, as I've said, has the skills requisite for that kind of business and to hopefully make better business judgment calls. So that's her first duty. And once she's appointed the board has the authority then to direct the company, steer the company, as we sometimes said. And you can't have the chief executive appointing to the shareholder, the representative shareholder.
But couldn't we go back to the old model? I remember reading a report of the South African Railways in the 1940s. They actually talked in those days about the shareholder being the public of South Africa, but it wasn't a state-owned company in the sense it is now. But the general manager of the South African Railways reported to the Secretary of Transport, like the Director General, and in effect the Minister. It was very simple.
I think in those days, David, I may be wrong, but South African Railways was not a company.
No.
It was a state entity.
So I'm saying, shouldn't it go back to being a government department if they want to run it?
Well, my own view, it shouldn't be owned 100% Eskom by government, because when you think about it, it's a debt equity problem, and you should actually get private participation to provide capital, and then private input in the management as well, because you could solve the problems. First of all, the problems of the capital needed, the amount of money needed to promote it, and you then have a private partnership, and it'd be run as a public-private company.
Well, you mentioned duty of care, and this is what directors should have. In the instance of Eskom, or generally speaking, is this what we've been seeing in terms of corporate governance?
Well, I can't say, because I don't sit in the boardroom and I don't know the facts of my own knowledge. But it's, of course, speculative, because of the suspension of the 4 senior executives as to whether they have been discharged in their duty of care to the company. I can't answer that question because I don't know the facts. I find the suspension in itself interesting from a governance point of view, because the Companies Act doesn't provide for suspension of directors. Directors have a right and a duty to attend board meetings, and so I can only assume that there's something in the compact between the company and the minister to allow suspensions, or there's something in the memorandum of incorporation allowing the board to suspend other directors. But there must be something.
But could it follow from what you've said that the Eskom board has acted illegally in terms of the Companies Act in suspending those executives?
Well, I can't say that because I don't know what the compact says. That's a contract between the shareholder and the company. And I don't know what the articles in the memorandum of incorporation says. I can only assume that's where the power comes from. Alternatively, the 4 directors by agreement agreed to suspension pending the inquiry.
Thank you so much for making the time to join us today and explaining some of those concepts to us. That was Mervyn King. He's the chair of the International Integrated Reporting Council.